Today I'm diving into a legal thriller that unfolded not in months or weeks, but literally overnight. Imagine this: the Supreme Court springing into action at midnight to stop the government from deporting a group of suspected gang members under a controversial law from 1798. This isn't your typical sleepy judicial story. It's a constitutional emergency that woke the justices from their slumber and pushed them into issuing a historic Saturday order. Join me, a constitutional litigator, as we unpack this. Why did the Supreme Court break all its usual rules to intervene? What constitutional boundaries did they redraw in the process? Stick around as we unravel exactly why the court acted so urgently and what it means for the future of constitutional law. Special thanks to our viewer Scott for suggesting this very story. Normally, courts aren't known for their speedy service, especially outside of business hours. But in this challenge at the Fifth Circuit, within hours of the emergency filing at the Supreme Court, relief was granted. Ultimately, the Supreme Court ruled 7-2 in favor of these detainees, finding that the skimpy notice the government gave them surely does not pass muster under due process. The case got sent back to the Fifth Circuit for a full review, but the bottom line is the court intervened with lightning speed to protect the due process rights of these suspected alien gang members. Enter Judge James Ho of the Fifth Circuit. He's the judge who wrote a fiery concurring opinion when the case came back on remand. Judge Ho was not exactly gentle with his Supreme Court bosses. See, the Supreme Court had faulted the district judge, Judge Hendricks, for taking too long, a whopping 14 hours and 28 minutes to act on the immigrants' emergency motion. According to the Supreme Court, that 14-hour overnight gap was tantamount to refusing to rule at all. Judge Ho found that absurd. He basically said, hold up, folks. Expecting a judge to be on call at 12:34 a.m. is like expecting a 24-hour diner service. We seem to have forgotten that this is a district court, not a Denny's, Judge Ho quipped. In other words, judges shouldn't be obliged to hop out of bed in the middle of the night just in case someone files a last-minute motion. He joked that if this is the new normal, maybe Congress should fund 24-hour judicial operations with night shifts and all. His point: courts are courthouses, not late-night diners. Judge Ho's colorful opinion didn't stop there. He suggested something pretty provocative. The Supreme Court doesn't intend to make every case a 24/7 emergency. Then maybe it's giving special treatment to certain favored litigants. In this instance, those favored litigants were, in his words, members of Tren de Aragua, the Venezuelan gang, which he argued sure makes Lady Justice look like she's peeking from under her blindfold. In short, Judge Ho was accusing the court of inconsistency, even bias, in whose emergencies get the red carpet treatment. So that's the backdrop: a high-stakes immigration showdown where the court sprinted to the rescue, and a judge who basically said, Supreme Court, this isn't Waffle House at midnight. What gives? Keep that scenario in mind, because we're going to flip back to 2021 to look at a very different case where the Supreme Court's sense of urgency was, shall we say, more relaxed. Let's rewind a couple years to the height of the COVID pandemic. In John Doe's 1-3 versus Mills, a group of Maine healthcare workers brought a religious liberty challenge. Maine had a strict COVID vaccine mandate for healthcare workers. No jab, no job. And crucially, no religious exemptions allowed. These nurses and doctors, proceeding anonymously as Does, believed the mandate violated their First Amendment free exercise rights. So they urgently asked the Supreme Court for an injunction to block the mandate before it cost them their jobs. You might expect religious freedom claims to get the court's attention. After all, we're talking about law-abiding citizens who just didn't want to violate their faith. But here's what happened. The Supreme Court refused to grant emergency relief. On the very evening the mandate was to take effect, October 29, 2021, the court declined to intervene. Essentially, the message was, sorry, we're not stepping in on this one. Several justices dissented. Justice Gorsuch wrote a passionate dissent on behalf of the religious objectors. But the majority held firm and let the mandate proceed. Why no help from SCOTUS? Interestingly, Justice Amy Coney Barrett, joined by Justice Kavanaugh, penned a short concurring opinion explaining the decision to deny relief. She cautioned against using the court's emergency powers, sometimes called the shadow docket, too freely, Barrett worried about the court being forced to give a premature thumbs up or thumbs down on weighty issues on a short fuse without benefit of full briefing and oral argument. In plain English, she was saying, we don't want to rush major decisions. In the main case, the litigants had only given the court about 9 days from start to finish to consider the emergency application. And to Justice Barrett, 9 days was just too little time to responsibly adjudicate such a big constitutional question. Better to pump the brakes, let the case go through the normal procedures, get full briefing, and so on, rather than issue an emergency injunction in a hurry. And let me pause here to speak from experience. As someone who's litigated First Amendment cases in federal court more times than I can count, this part absolutely burns me up. Everyone knows the Citizens United case, the case people love to hate. But fewer remember that its origins trace back to Wisconsin Right to Life from 2004. That case challenged the exact same electioneering communications ban. And what happened? 2 trips to the Supreme Court, procedural ping pong, and in the end, just a lukewarm ruling telling the FEC, hey, maybe try respecting free speech next time. The FEC didn't. They ignored the ruling. And it wasn't until 2010, 6 full years later, that the Supreme Court finally gave meaningful relief in Citizens United. Think about that. A speech ban sat in place for over half a decade while the courts navel-gazed about whether, when, and how urgently to act. This is not some fluke. This is how courts routinely treat First Amendment claims, especially ones that aren't politically fashionable. Judges downplayed the immediacy of the harm, let the cases languish, and act like it's no big deal. Meanwhile, people's speech rights are frozen under government restrictions that everyone agrees raises serious constitutional questions. That's not how a system that claims to value free expression should behave. It's judicial apathy, wrapped in procedural formality, and it needs to change. So, back to the Mills case. Those Maine healthcare workers did not get their injunction. They had to either comply with the vaccine mandate or lose their jobs while they had their legal challenge continue at a normal pace, that is, slowly. The Supreme Court essentially told them, we're not going to leap in and override Maine's mandate overnight. The value at stake here was religious liberty, and the court's approach was cautious and slow. They prioritized judicial process over the applicant's urgent plea, suggesting that immediate relief was reserved for only the most clear-cut and critical situations, and apparently this wasn't one of them. But bear in mind, other litigants did win religious liberty challenges to COVID mandates on a slower time frame after this case. The Ninth Circuit recently ruled in favor of 2 San Francisco employees who were terminated due to their vaccine refusal based on religious beliefs. Military members won religious exemptions to vaccines, and the First Circuit permitted a lawsuit by Maine healthcare workers because Maine did not permit religious exemptions. But in a lot of these cases, waiting years for relief makes the victories rather pyrrhic. Damage is done, litigation funds get eaten up, and controversies usually are over. Now let's put the 2 main cases I've been discussing side by side. We have the first case where the court drops everything to help suspected gang-affiliated aliens, and the second case where the court takes a rain check on aiding religious objectors. Is there a double standard here? Judge Ho certainly thinks so, and it's hard not to notice the contrast. Let's break down the key differences. In the AARP, not the senior citizen, but the immigrant case, the timeline was hours. The lawyers went to the district court at lunchtime on Friday, and by the next morning, the Supreme Court had effectively intervened. In the Maine religious liberty case, the timeline was days, about 9 days to be exact, and the court said that was too rushed to act. As Judge Ho dryly observed, 9 days is a lifetime compared to 42 minutes. In Maine, it was law-abiding U.S. citizens, nurses, healthcare workers, raising constitutional claims about freedom of religion. In the Texas AARP case, it was undocumented immigrants, illegal aliens with alleged ties to a violent foreign gang, raising claims about procedural due process. Ho explicitly contrasted citizens concerned about their religious liberties with illegal alien members of a foreign terrorist organization. The former got slow-walked. The latter got the court's red carpet express service. In Doe v. Mills, the majority's reasoning, per Justice Barrett, was we shouldn't be forced into snap decisions. This needs full briefing and considerate deliberation. Essentially, we'll wait even if that means people lose jobs in the meantime. By contrast, in the AARP case, the court acted immediately to prevent potential harm, deportation, even before the lower courts finished any process. The Supreme Court didn't wait for a full briefing. It jumped in on a short fuse without apparent hesitation, even on a weekend. The concern for giving everyone a slow, careful process seemed to evaporate. Judge Ho found this contrast pretty galling. He pointed out that the district judge in the immigrant case likely assumed the Mills principle would apply equally. If 9 days was too little time for the Supremes to act for nuns and nurses, surely the judges wouldn't expect action in mere minutes for gang members. By that logic, Judge Hendricks's 14-hour pause wasn't laziness, it was prudence, taking time to craft a thoughtful ruling. As Judge Ho noted, the district court even said that issuing a competent decision required some level of care. And some level of care, well, it takes time. Justice Alito, who dissented from the Supreme Court's move, agreed, saying the judge's careful approach should be commended, not criticized. Yet the Supreme Court majority effectively flipped the script in the immigration case. Ho's frustration practically leaps off the page. Why the special urgency for this particular case? He posited that the Supreme Court was giving special treatment to what he called favored litigants. Here, the non-citizens tied to a gang, which sure looks like bending the rules. He implied that perhaps the politics or optics of the case influenced the court's eagerness. Was it because the case was high profile, pitting the ACLU against the Trump administration? Was it to signal the court's fairness in an immigration context? Ho doesn't spell out motives, but his pointed sarcasm about Lady Justice not really being blind says it all. It's a sharp critique. The court appears to have one standard for religious liberty and free speech claims, slow down, no emergency intervention, and a very different standard for procedural rights of potentially dangerous aliens. Full speed ahead, let's intervene right now. If true, that's a troubling inconsistency. After all, justice is supposed to be neutral. The symbol of Lady Justice wears a blindfold for a reason. If that blindfold slips whenever a case has certain political overtones or media attention, it undermines public trust in equal justice. Take a look at the front of the Supreme Court building. Carved in the marble above those imposing columns are the words, "Equal justice under law." That's the ideal, no matter who you are, nun or gangster, citizen or immigrant. You get the same fair shake when you come before the highest court. Emergency orders especially should not depend on the court's mood or the case's politics. Whether it's a group of nurses seeking an injunction or a group of detainees seeking due process, the standards for relief should be consistent. What Judge Ho highlighted is a perceived lapse in that ideal. He effectively asked, is justice truly blindfolded? Or is she peeking to see who's in front of her? If a vaccine mandate challenge can wait for full briefing, but a deportation flight gets grounded in hours, it raises an eyebrow. In a witty way, Ho reminded us that courts shouldn't run like 24-hour diners for some cases and a slow-moving bureaucracy for others. In the end, this comparison isn't about choosing whose cause is worthier, religious liberty or due process. Both are vital. It's about the court's role and credibility. The Supreme Court showed it can move at warp speed to prevent irreparable harm. So why not apply that urgency even-handedly? Is due process more important than religious liberty? Why? Equal justice means equal standards, especially on the emergency docket. The real-world impact is huge. People's jobs, people's freedom, even where they might spend the rest of their lives. It hangs in the balance. If nothing else, the tale of these two cases teaches a civics lesson with a side of satire. When it comes to emergency justice, the court should strive to treat every case with the same care, whether it's being argued by a nun or an ACLU lawyer. Otherwise, we'll keep asking the cheeky but serious question. Is the Supreme Court a temple of law, or does it sometimes serve favorites like it's a late-night Denny's? Equal justice under law deserves nothing less than a consistent answer. Thank you for joining me today. My goal as a constitutional litigator is to equip you with the tools necessary to solve today's constitutional controversies. If you like this channel, please be sure to like this video and subscribe, as it really helps me with this educational project. Remember to join us next episode as we tackle yet another constitutional controversy.